Welcome to Reducing Risk, a series of podcasts from Medical Protection created specifically for doctors in Aotearoa, New Zealand. Reducing Risk looks at key medico-legal issues in our jurisdiction and provides helpful advice and guidance on how to manage those risks. Today we continue our series on demystifying the New Zealand Medical Council standards, and we're going to consider the question, do I have a commercial conflict of interest? What it is, Medical Council standards, and how to avoid complaint. My name's Dr. Sam King. I'm a medico-legal consultant with Medical Protection and a GP. And today I'm joined by Ms. Kate Wills, who is a Senior Associate at Whitten & Carney Law Firm, our panel law firm. So good to have you with us, Kate.
Thanks, Sam.
And I'm also joined today by Dr. Lucy Gibbard, who is my fellow medico-legal consultant and also a GP from Taranaki. Welcome, Lucy.
Thanks, Sam.
Now, there was a complaint raised recently to the Medical Council which has prompted interest in the area of commercial conflict of interest. And this is an increasingly common occurrence as what is within our vocational scope expands. So, for example, cardiologists routinely perform echocardiograms where they have their own machinery, and of course they charge for that. O&G routinely perform ultrasound scans for assessment and procedures. It's common practice to charge for both their opinion and additionally on-charge costs associated with the expense of these other investigations. Surgeons and other proceduralists may have a shareholding in a private hospital or treatment facility that they derive financial benefit from. GPs may or may not have ownership in a rest home or perhaps a skin or appearance medicine clinic. And of course there are also the cannabis clinics where doctors work and own those as well, where they both prescribe and sell products. So let's start with a fictitious case. Let's say there are a group of 6 urgent care doctors who've bought 50% shares in a local radiology clinic, which has been set up in the neighbouring building. The GP patients who require x-rays and ultrasounds, which are usually funded by ACC or under a PHO scheme or private insurance, are referred to this new facility. It's convenient for the patients and saves time for them, which means that the reports are available a little faster than otherwise would be the case. There's a competing radiology clinic 2 kilometres away who are suspicious of overuse of the new radiology services and has noted a significant drop in the referrals received from the urgent care clinic. They raise a complaint to the Medical Council, stating that the urgent care doctors are acting unprofessionally and in contravention of the Medical Council's statement. So Kate, perhaps to kick us off, what do we mean when we say there's a commercial conflict of interest?
So helpfully in this context, the Medical Council has actually defined what it considers to be a conflict of interest, and that's set out in its guidance statement, Doctors and Health-Related Commercial Organisations. So that statement records that a conflict of interest arises when 2 or more sets of goals, values or obligations coexist in a particular setting and they are opposing or contradictory. For example, a situation where your own interests may be at odds with your professional responsibilities. The worry that arises from this is whether any other interests may detract from the primary obligation of doctors to make care of their patients their first concern. In that definition, the Council note that a conflict of interest is not limited to financial interests. It can include sort of broader things, non-monetary interests such as a person's status, reputation, relationships, or their research interests as well. The Council, they do recognise that a conflict of interest is not always avoidable. Doctors obviously do have the right to invest in or have business dealings with health-related commercial organisations, and in a small country like New Zealand, these interests may well intersect with the person's practice. Whether or not a conflict is acceptable will depend on the circumstances and what steps have been taken to manage or reduce that conflict. It should be noted that even a perceived conflict of interest has the potential to be as damaging as a real one. So even if it won't eventuate, it must still be recognised and managed.
So Kate, with regards to jurisdiction, how much jurisdiction does Medical Council have in terms of our business arrangements where doctors are shareholders in particular companies?
That's a really good question because obviously typically the role of ensuring fair trade practices, including the maintenance of fair competition, rests with the Commerce Commission. So The council's jurisdiction is confined to its regulatory task of ensuring that practitioners are competent and fit to practice and that they are meeting their professional obligations in place to protect the public. So the council cannot interfere beyond its regulatory mandate.
So, Kate, does the way the doctors financially benefit matter?
It would, yep. So some conflicts in business arrangements may not be able to be managed in a way that provides enough reassurance that a practitioner's driving motivator is patient care as opposed to their own interests. So just giving some examples of that, it might be hard to justify to the council situations where a practitioner receives sort of direct financial kickbacks or other benefits for making certain referrals or providing certain medications. The council may be a bit concerned if dividend payments are dependent on referral numbers. There could be a problem if someone close to the practitioner, for example their partner, has travel, accommodation or other costs covered in association with the practitioner's attendance to a sponsored event. And there may also be sort of a bit of concern where payment to attend or present at an event or to engage in research is disproportionate to the amount of time spent and the work required.
Thanks for answering that. So, Lucy, maybe I could ask you, would you mind explaining the main concerns Council have, which they've stated in their updated statement that they posted recently?
Yeah, so the Medical Council have updated their statement on this, and it's called the Doctors and Health-Related Commercial Organisations. And the key points in it are that the Council are concerned that having a commercial interest in, say, a radiology company like this example that you've had can influence how doctors practice and the clinical decisions that we make. So it's really important that we actually recognise that potential influence and take steps to avoid or manage any bias or conflict, whether it's real or perceived. As Kate said before, it's important that we recognise it and that we act to make sure that it isn't impacting on our professional standards. Equally, failure to do so could compromise our clinical objectivity, and we need to be aware of that. And it could lead to unnecessary tests or inappropriate use of health resources, doing more x-rays than you normally would have done because you think it's going to benefit your company that you own. The issue then as well is if it's a perceived issue as well as a real one, is the eroding the trust and confidence that patients have in doctors and how the public perceives the medical profession. You definitely get from patients sometimes, the cardiologist ordered all these tests. I think they would, just wanting to do an echo for that reason. Well, you don't often get that. I should rephrase that. But, it does happen that people perceive that they are being asked to undergo tests because of commercial interests. So it's absolutely vital that transparency and integrity are clear. So we must ensure that our conduct and decisions justify our patients' trust in us and the public's trust in the profession. And as Kate said before, it's all about the care of the patient. That's got to be our primary concern.
Yeah, so the the patients are central to all of this, aren't they? And it is about patient care after all and not financial gain ultimately. So Lucy, just thinking about the scenario that we talked about with the 6 urgent care doctors, do you think there would be a conflict of interest there?
Well, potentially, yes, I have to say. And the fact that somebody has raised the concern with the Medical Council in your scenario suggests that at least there's an appearance of a conflict. It seems that we would hope those urgent care doctors are not going to be ordering tests unnecessarily. Obviously, urgent care order lots of x-rays all the time anyway. But look, patients can feel unhappy about paying for investigations, and if they are made aware that the doctor is actually financially benefiting from that investigation being done, there may be a perception that it's been ordered for the wrong reasons.
That's true. So, Kate, in this situation where someone's complained about these urgent care doctors owning these shares, do they have to sell their shares? Or, is there a way that they can avoid running foul of the Medical Council statement?
They wouldn't, in my view, it would be sort of extreme if they had to sort of proceed immediately to sell their shares. I think there's a number of things they can do lesser than that to manage the conflict and reduce any concerns arising around it. The council in its statement sets out some steps, sort of minimum steps that should be taken to hopefully achieve that. First of all, any referral must be clinically warranted and justifiable. And obviously, as doctors always do, that's got to be set out in the notes, and you've be able to produce that to confirm that that is the case. When the practice next door is proposed as an option, the practitioner must disclose at the time of the referral the nature of the financial interests that they have in the facility. So in your example, Sam, they should tell the patient that they have shares in the practice. They should explain that their interest in the practice is not the driving motivator behind suggesting it, and that the practice next door is one of a number of potentially suitable alternate options, including the one down the road. They should mention that. Any information about the practice next door and alternate options, for example, around cost, wait times, that sort of thing, should be accurate to enable informed decision making. And most importantly, it should be made clear to the patient that they have a choice and that whatever choice they make will not impact on the care the practitioner provides. It would be prudent and sensible to keep a record of the disclosure of your interests that's been made.
So in terms of, if you think about, as Lucy said, urgent care doctors just order x-rays just all the time. Do you think it's necessary to say to every patient, that I'm a shareholder in the radiology place next door, and then say there's another one down the road? Or would it be sufficient to just have a sign up, say in the clinic, or even on the request form? Would that be sufficient?
You can obviously communicate that message in a multitude of ways. You can have it on your onboarding documentation, you can have a sign up, but the council does expect that the disclosure happens at the point of referral, because that's when it's relevant to the patient. And there's always a risk. And, there are times when you turn up to a doctor's practice and get given a bunch of information and you don't necessarily actually read it.
Really?
Yeah, whoopsie. Maybe that's just me. But, disclosing your interests at the point of referral is the safest option, because you can be clear that the patient has received the information at the point they need to. You can't be so sure that they've received the information if it's at the bottom of one sentence in the bottom of onboarding documentation.
Yeah, and I think the other part of that is documenting that you've told the patient the options.
Definitely.
And I think that, so one, you've got to say, and second, you've got to document that they were offered alternative providers and that they were aware of your interest.
Yeah. It doesn't need to be onerous,
No.
It's a quick conversation, but the key is just to be open and transparent.
It does sound a little onerous, though, doesn't it?
I think it depends on how you say it as
Yeah.
well. I think, saying, this is part of our group. I'm part of, this radiology practice is part of our group. I'm a part owner of this group. I think that's saying what it is.
Yeah. And quickly followed by, but that is not why I'm recommending it. It's an option for you. There's also other options, which I'm happy to talk to you about.
Yeah, absolutely.
So, Lucy, for those doctors who provide the medication or product as well as the prescribing it, so we're turning away from the urgent care case now and thinking about some different scenarios. So there are some doctors who both provide the medication and product as well as prescribing, and those would be perhaps the cannabis clinics or even appearance medicine clinics. Are there any extra precautions they should take to minimise their risk?
Yeah, well, the good prescribing statement basically says you've got to make sure that you've got the care of the patient as your first concern, and you only prescribe medicines or treatments when you've assessed the patient's condition, you've got knowledge of their condition, and are satisfied that that is the right treatment for the patient and it's in their best interest to have it. So just because you're selling a particular brand of moisturiser from your appearance medicine clinic, you have got to say you've got to make a decision, is that actually the right thing for this patient? Have I talked to the patient about other similar options. The other issue here is that, some specialist clinics accept patients without referrals from their enrolled GP. And in those situations, it's harder to know, what the relevant history is for that patient. You're relying very much on what the patient tells you at that point. And that does create some risk for both the patient and the clinician. So just being a little bit careful in that situation. So first of all, you're deciding whether that prescription is warranted, given the nature of the patient's complaint and presentation. And then you've also got to think about whether there could be an adverse effect of that medication. Just as with anything you prescribe, consider whether no treatment at all is an option or whether there are other treatments that could be effective and safe. And then basically you've got to be open with that and actually say, well, this is one of your options, and that, but these are other options that you could consider. So the patient is making an informed choice. The other thing that's important in those situations is sharing information about prescribing with other health professionals who are involved in that patient's care, because we do have an obligation to ensure that there is continuity of care and that patients are safely being cared for, so that other clinicians may need to know about the medication that patient's been prescribed. So sharing of information includes verbal communication with other health professionals, but also written communications such as referral letters or clinic letters. It's important that you tell the patient that their information about their care is being shared, although actually under the Health Act there is an ability to share that information with other patients involved in the patient's care without explicitly having asked for consent. And it's really important that you're documenting your reasons why you're prescribing that particular medication or that particular treatment, and giving it all those disclosures about your own commercial interests at the same time.
Yes, for the multi-comorbid patient who's on multiple medications, it's very risky if doctors are prescribing blind, isn't it? There's a risk to the patient, and I agree there's certainly a risk to the clinician as well. Kate, is there anything else you'd like to add?
Yes, so just actually following on from that comment, Sam, I just reiterate the importance of ensuring that a client's or patient's other health providers, like their GPs, are informed where necessary. We've seen in my practice admitting to do this as a bit of a hot topic with the HDC recently. So there is risk to you as a clinician if you're not keeping others advised when they need to be. I'll comment just briefly on that point about providers sort of selling their own products. The council has prescribed requirements around this in its Doctors and Health-Related Commercial Organisations statement, and these include fairly detailed record-keeping requirements, so it's definitely worth having a look at them. Just briefly, records must detail the actual cost of the product to you, including any rebate, discount or incentives you receive from the manufacturer or supplier. It must include the manufacturer and supplier's names, the date the product was manufactured and supplied to you, any expiry or best before dates, and it's also you need to record any additional costs you incurred in sourcing the product, including any formula or calculation you use to set the sale price.
So you've got to have that recorded somewhere. So if you're selling moisturiser to patients, you actually have to have all those things set down about, the cost of you to do that and the formula that you've used to calculate the sale price.
Yeah, well, that seems to be the council's really up-to-date expectation with this new statement coming out in February 2023. And it's must,
Interesting.
That's where it sets the...
And then is the potential then that they could criticise you if that formula is unreasonable?
I guess
it doesn't specifically say that.
Yeah, I think they could learn a number of things from this type of information. I thought one of them could be, it could provide them a bit of an indication as to whether your interests are being a bit swayed by the suppliers or manufacturers that you're getting this product from, and whether that impacts your objectivity.
Yeah. I think the classic one for this in general practice has always been, and it's not now, but in the past, the whole thing about EpiPens, where the cost to a patient of an EpiPen was very high. So doctors were getting them in and supplying them actually to make the cost less to the patient. And so I think they wouldn't fall afoul of that regulation. But it's an interesting thing that you've actually got to have all that recorded, isn't it?
Lucy, when we attend clinical conferences, we often receive free samples, we enter competitions to win, I don't know, trips away or whatever it happens to be. And there are other inducements such as sponsorship and research grants and, travel for conferences. Do you think there's an issue with this?
Yeah, and I think it is regulated, but the research does show that doctors who accept gifts or inducements or sponsorship can often then have a positive bias towards those companies' products. So the reason drug companies or other companies do it is because it works, and so I think we have to be very aware of that. And I know there are many doctors now that would rather not be involved in anything where it has been sponsored by a drug company because they're aware of those concerns with bias. But having said that, equally, there are some of those situations where those companies are providing important educational roles or other things. So I don't think we can say it's absolutely not appropriate, but I think we actually have to have it in our heads when we are attending those or being involved in those kind of situations, that we're actually aware of it. And the Medical Council says that we do need to recognise these conflicts and avoid or manage them to ensure we are actually remaining objective within our clinical decision making, basically.
Yeah, that's a really interesting thing because, just for myself, it never occurred to me that I would be influenced by a box of jelly beans or something that I've picked up at a conference. But if that's what the research shows, I think that's very interesting.
Yeah, and they wouldn't be doing it if it didn't.
That's true.
That's
true. So, Kate, are there any other ways we can avoid having issues?
There are, or there should be, some safeguards at these conferences around the information exchanged. For example, the presenters, if they're medical, they'll have their own professional obligations to present information in a balanced and unbiased manner. So that should provide a bit of a safeguard. Of course, it would also be sensible, nonetheless, to be, as Lucy said, alert to the motivations and influences that may be at play and mitigate the potential effects of these through, for example, critically appraising the information received. Also, through actively seeking out unsponsored, objective information about treatments, devices, products or services. Of course, too, a good way to make sure that your sort of finger is on the correct pulse is regularly engaging with your colleagues and keeping up to date with current best practice. This is a safeguard against sort of getting sucked into these big flash drug companies' presentations.
Yes, we don't want to get sucked in, do we?
No.
So is council adverse to doctors being paid by, say, a drug company for work done endorsing or speaking about a product for a commercial company?
The council doesn't prohibit this sort of conduct, but it does identify risks around it that must be managed. Because like all professionals, it's appropriate for doctors to be compensated for the use of their skills and experience and knowledge. But because financial transactions have the potential to influence clinical judgment, be it consciously or subconsciously, any fee or payment accepted for assisting should be a fair reflection of the services actually provided. It should be proportionate. In these sorts of arrangements, you should make sure that there is a written agreement that outlines the nature and the scope of the services you will provide to the health-related commercial organisation, and also the disclosures that you may need to make to relevant parties, such as your patients, your employer, or a research ethics committee. And that's sort of sensible because it focuses both parties' minds on, this is what I'm talking about and what I will be saying. There could be a risk arising from this that I need to disclose. It's helpful too for the drug company or whoever is asking you for that assistance to know your parameters and the fact that you're alert to conflicts potentially arising and committed to managing those. I guess also, if you're speaking at an event, the council expects you to ensure a number of things. They expect that the purpose of the event is educational and not commercial, and that there's a clinical or scientific basis for it. They expect that the information you provide will be balanced and unbiased. If you're presenting, you must make a disclaimer that your presentation is not an endorsement of the product. the council would encourage you to use generic names rather than trade names wherever possible. And it's expected that you be open and transparent about any relationship you have with the company. That's going to be really important.
It's interesting about that generic names. I always think the one that really is difficult for that is the inhalers, because the actual real generic names are a complete mouthful, and they're often, they're medications that have got more than one medication in it. But the drug company name is nice and short, and everyone knows it. So I think that can be actually quite challenging to say, use umeclinium or whatever you're going to be using, rather than actually the drug company name. So I think that's interesting.
They provide a little bit of scope, so they do say where possible. So that gives you a little bit of wriggle room around. It's not a strict requirement
so
to always
impossible to use a really long. Yeah, it's interesting.
So another area where we don't tend to think about commercial conflict, but is mentioned in the statement, is around gifts that we might receive from patients. So, Lucy, I'm sure you've received some gifts from patients, and often it's just they might pop in a few muffins or something there for the staff for morning tea, which, everyone would think is very harmless. Although I remember some years ago there was one patient who brought in a batch of baking that she'd made, and we were just uncertain about this particular patient, so none of us would eat it. But usually we take it with great delight.
Yeah.
But what about something of much high value? Let's just say a patient gives you an expensive watch, for example. What should we do then? And how do we know if we've got a conflict? What do you think, Lucy?
Yeah, I have to say I have a lovely patient who brings lemon curd, lemon honey.
Oh, yum.
Yeah, I have to say I say yes to that. I'm so sorry.
Guilty.
Fair cop. But yeah, I think if it's an expensive gift, and I think things have changed over the time. I was telling Sam earlier that my father, who was a doctor, and this is more than 50 years ago, was given a grand piano by a patient. And I think that would be considered totally inappropriate in this stage. I don't think it was particularly in those days, because I have to say we did have a grand piano, courtesy of that patient. But in general, what we are expected to do, that if that gift is one that might impair our ability to provide objective care, then obviously we can see that would be an issue. If you end up feeling obliged to that patient, or that you would be treating them differently than any other patient because of that gift, that's definitely something that should be raising warning bells with us. And gifts at that different level from muffins and lemon curd, we should actually be thinking about that and thinking, should I accept it? Should I not? And I think if it was something like a watch, I think the best thing to do is actually to politely refuse it and say, look, I'm really grateful that you thought of me. However, there are standards that the Medical Council has set, and I'm really not allowed to accept this kind of a gift from a patient. So thank you, but I have to decline.
It must be hard sometimes, though, to say no, even if it's a really nice gift. But I'd have to say I've never had the opportunity to say no. I've only had the muffins. So, Kate, what about the patients who intend to leave a sum of money in their will?
This might be stating the obvious, but the council expects practitioners to discourage patients from bequeathing money or gifts. As Lucy just canvassed with gifts, the best option would be to refuse a bequest with a polite explanation, and putting it back on the council is a good way to sort of distance yourself. It's not that you don't want it or appreciate the offer, it's just that there are expectations that mean that you can't accept it. So you could give that polite explanation or request that it be reassigned to someone or something else.
But what if you don't find out until after the patient has passed away that you've been bequeathed a sum of money?
The council's guidance doesn't address a situation like this, where a doctor learns of a gift from a patient after the patient's death. But in such circumstances, concerns about the gift blurring professional boundaries, causing risk to patient care, or influencing imminent care decisions are obviously no longer factors to consider. But I think the gift could still prompt questions or concerns about the nature of the relationship between the doctor and the patient when the patient was alive. And risk could arise around that obviously the extent of what that risk could be will be dependent on the circumstances of the particular case. So when you're sort of weighing up those circumstances, there's a few things that I would suggest you think about. The nature of the relationship will be relevant. Was it long-standing? Was it very involved? Sporadic, everyday? What was the medical problems an issue? Those sorts of things. The vulnerability of the patient will need to be understood. If they didn't have capacity at the point the gift was directed, that obviously would lend to it not being acceptable to accept. Information on motives would be helpful if you could find that sort of thing out. Did the practitioner and the patient ever discuss the estate and the patient's plans around that? Did the patient's family know why the gift was left? Things like the value of the gift will be relevant. If the sum is significant, that's going to come with more risk in accepting it. It could prompt an inference of the blurring of professional boundaries while the patient was alive, or at worst, exploitation. If the gift is significant, I think there's some sort of steps that I'd suggest you move through. Definitely engage with your colleagues and be open and transparent about what has happened. Obviously, you can talk to the MPS too, and sort of additionally you could contact a lawyer just to obtain an objective view on whether the circumstances lend it to be ethically permissible to accept the bequest. If the advice received from those various people that you talk to is that accepting the money could be okay, I would suggest nonetheless, if it's a significant amount, that the medical counsel be notified of the gift. Tell them about the gift, also tell them about the advice you've received, and notify them of your intention at that stage to keep it, and invite the counsel to communicate any concerns. I just think it would be quite prudent to receive a steer on whether the counsel had any worries at an early stage, so that the doctor could then consider any professional risks were they to accept the gift, and were the counsel to take action in response. While you're sort of sorting that out, taking advice and potentially notifying the counsel, I definitely recommend that the money should be protected and not spent until the counsel's position is understood. And I think it will also be very important to document any actions taken and advice received in case there is a need to account for or explain it later.
That's really helpful. I don't know how often it is that doctors receive a bequest, but I'm sure it will be a dilemma for those who do.
No, there has been a medical protection case for that, where it was a 6-figure bequest to a doctor. So it does happen.
It does happen.
Not to me, I have to say, not to me, but it does.
Oh, well, thanks, Kate and Lucy, for discussing this medical counsel statement. I think that in particular, the commercial conflict of interest is probably something that we don't tend to think about because it's the business side of medicine. But it's interesting to note that counsel do take an interest in it, and there have been complaints to counsel around this whole area. And as we said earlier, particularly when you've got doctors who are ordering tests and then gaining financially from those tests.
It's always a little bit hard though, that, because I mean, just circling back, is that, so you have an ECG machine in your practice and you charge a patient $40 to do an ECG. Is that a commercial interest? It's in your it's a service that you offer in your practice. If you offer, doing a wrist splint, and you charge the patient for that, it's when is it actually considered not part of your normal things that you charge for in your practice? Is it just because it's in a different building, or is it,
I guess it comes down
grey
to clinical indication. If you can justify it clinically, then I think it would be reasonable. And let's face it, charging $40 or $50 for an ECG is actually a very small sum of money. So in my opinion, it can only ever be seen as a service. I don't think GPs get rich on doing ECGs.
On doing ECGs. But the reason I think about that is that I have seen a complaint where the patient complained that they had an ECG ordered when they thought it was unnecessary and got charged for it, and that was their concern. And I wouldn't have even thought about that. But there is some grey in there, isn't there? But I think it's just making sure we're aware, and that if you have got a financial interest in services, outside core general practice, that actually you need to make sure that you're actually letting patients know that and documenting that you've let them know.
Yes, that's great. So thank you for listening to this podcast. I hope it's been helpful. We look forward to catching up with you in our next podcast. If you like the Medical Protection podcasts, please subscribe and leave a review. If you would like a podcast on a specific topic, please email nzpodcasts@medicalprotection.org. Thank you, Kate. Thank you, Lucy.
Thanks, Em.
Thanks, Sam.
And we'll catch you all next time.